Starting at page number 1 of the contracts, this is a talent management agreement. It has been redacted, so it is not involving any of their special private information here. We've got talent management between MSM Media under the laws of Maryland and the artist, which has been blacked out, who's an individual over the age of 18. So these guys are not Vactor, they're not they're not whatever other people, other agencies contracting people underage. They're contracting people of age, right? So you've got that here with MSM Talent. The manager is the provider of management services, and the artist seeks to engage the manager to obtain a service. Well, simple enough. Your contracts don't need to be complicated. This is perfectly fine from a legal standpoint. Now, therefore, in consideration of mutual covenants and agreements herein and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the parties agree as follows. This, by the way, checks off a box in contracts called consideration. Every contract has to have something called consideration, meaning there has to be things exchanged between both parties. This is a boilerplate standard term in almost all contracts because it is checking off the box, check, of consideration, saying this is a valid contract because you have two parties, you have mutual agreement, and you have consideration. So this checks off that box. Definition says an agent, any individual, group of individuals, entity, or group of entities who are engaged to solicit the commercial exploitation of the artist's service, name, image, likeness, and brand. So these are definitions. So artist means pretty much anybody who's doing art stuff. Games industry, all services and activities related to the game and video game and tabletop industry. Gross income is including fees, royalties, bonuses, shares of profits, stock, partnership interests. Directly or indirectly by the artist received on their behalf in any way related to their services. Gross income does not include revenue generated directly from streaming or social media, including donations, subscriptions, bits, personal engagements. Let's go to page 2. Third-party engagement. So gross. When we talk about gross income, it does not include third-party engagements or any existing agreements for engagements that were in effect prior to the execution. So meaning if this person had an agreement with another agency or another sponsor and that was predating this, that would not be considered as the gross income. So media, all services related to television and film, not related to promotion, on-screen appearances, acting, guest appearances, advising, commercial, music industry. All services related to music, including but not limited to promotion, music production, mixing, mastering, live events appearances, guest appearances, collaborations, and personal and commercial productions. These are very standard definitions, which seem to be pretty accurate as to media and music industry. Personal engagements, meaning engagements the artist is managing on their own behalf without assistance of the manager's services. So this would seem like something that's going to fall outside. The streaming industry, all services, platforms in any way related to live streaming of content, including, for avoidance of doubt, but not limited to Twitch, YouTube, and Facebook. So the main streaming platforms. Third-party engagements, meaning engagements secured by a third party like an agent in which the manager does not provide services. VA industry, all services and activities in relation to podcasts, audiobooks, commercial voice acting, audio production and mixing, TV voice acting, movie picture voice acting, and any other exploitation of their voice acting abilities. This agreement is in effect for 1 year and shall automatically renew for periods of 1 year thereafter until it's terminated. Either party may elect not to renew the agreement upon notice to the other party with at least 30 days prior to the expiration of the term. Manager shall reasonably inform artist of a renewal date within 60 days of such. Okay, so either party at the end of the year term, so it's renewing from year to year, an automatic renewal, which is very standard. Automatic renewal, this is normal. I would write a contract like this. I've written contracts like this. I actually prefer 2-year blocks. I think they tend to be better, but 1 year is fine. It's automatic unless you say so. So you've got to give at least 30 days notice before that, but you know what the date of the contract is, so you're able to come back and say that. That's actually it's actually not a bad thing. That's actually not a bad thing. So this is not yet Niji Sanji level. Right. So once again, this is not some sort of crazy termination clause. Non-exclusivity. So the agreement is non-exclusive. The artist may attain similar management services so long services under this agreement are not impaired. So they are allowed to go out and like, seems like they can work with Vishojo or somebody else. So it seems like that's there. Artists shall timely notify manager when such additional services are secured to determine whether collaboration is required. Okay. So if you've got a pre-existing contract, they really don't talk about that. But afterwards, right, because they've said anything that was before, they can't touch. That's not included. But anything after, they are, should be given some time when you are securing other resources. That's not unreasonable. Territory of the manager's representation is worldwide. This is important because VTubing is going to happen all over the world. Management encourages the artist to find alternative assistance for work outside the U.S. So they're saying, hey, we're primarily a U.S. thing. So if you're working outside the U.S., go elsewhere. This is not bad. This is actually not bad at all. It's kind of positive so far. Management says artist hereby retains manager as their non-exclusive representative throughout the territory. So we're talking about, worldwide, right? So for management, representation, advising, and streaming via games, music, and media, and any other industries they wish to engage manager on during the term and any extensions thereof. Managers shall render such services as are usually performed by an artist's personal manager, but not limited to advising them during negotiations of employment or exploitation of the talents and products, supervising their employment engagements on their behalf, consulting with employers and prospective employers for proper use and demand of their services, being available at reasonable times to talk about their career, business interests, employment publicity, advising on exploitation of the brand in all media and in connection thereof, subject to the artist's approval or direction to permit for the purpose of trade, advising, and publicity, the use, dissemination, reproduction, and publication of all the artist's intellectual property and publicity rights, such as their trademarks, copyrights, name, likeness, facsimile, signature, voice, and artistic and musical materials. At the artist's direction and subject to the artist's approval in each instance, engage in discharge or direct the artist's agent, as well as other third-party service providers for the benefit of the artist, collectively the services. All right. Okay. And then artists in their sole direction may submit personal engagements or third-party engagements to the manager for advising thereon and for the performance of the manager's services related to thereto. So accordingly, by definition, such matters shall thereby cease to be personal engagements or third-party engagements, and all revenue shall be treated like gross income. Because remember, if you are doing something personally or third-party, that is not income that they're collecting. So once again, they're not collecting income on things that are third-party or things that are personal. Artists must consider any proposed advice and or activity suggested by manager in good faith. What does this mean? Must consider in good faith. Does that mean you have to adopt it? No. But that means you can't just automatically reject it in bad faith, meaning you say, oh, well, because you suggested it, I'm automatically going to turn it down. It's very hard to prove good faith. So that's why things are typically required. And this is something that is very difficult to prove in court, right? About are you cooperating in good faith or not, right? But this is what this means, right? So you must consider advice in good faith. Okay. Using artists' reasonable business judgment after conducting reasonable due diligence on the advice and activities proposed by manager. Nevertheless, artist shall have the final approval. So the VTubers are having the final say. And shall not enter into a contract or binding agreement without artists express written approval. Okay, so the management cannot unilaterally do it. If this was Niji Sanji, this would be written the other way around. Manager and artist shall keep each other reasonably informed. That doesn't mean completely informed, reasonably informed of all material matters relevant hereto. This is very fair. I like this. This is actually a very good provision. It's very good. Manager services shall include the collection and receipt of all gross income intended for artists and deposit or cash any and all checks and other negotiable instruments of any nature and deduct therefrom, and retain any and all sums due to manager, compensating and paying out of gross income all sums due to third parties who rendered services to or on behalf of the artist or who are otherwise contractually entitled to such compensation. And the right to demand, collect, and receive all goods, money, and other items that may belong or be due to the artist. Manager's services shall not be exclusive to the artist. Nothing herein shall be construed as limiting the manager's right to represent other persons whose talents may be similar to or who may be in competition with the artist, or to have and to pursue business interests which may be similar to or compete with those of artists. Manager shall use its best efforts to exercise fair and reasonable business judgment in the circumstances. So once again, they're not limiting the rights on either side. The artist is not limited. The manager is not limited. This is very fair. Compensation. Here we go. Here's the money, guys. Here it is, the money shot. Compensation, 15%. Managers shall receive 15% of gross income. As specified, gross income is determined in relation to engagements where the manager performs services. Honestly, guys, to be honest, that's pretty fair. That's not a horrible percentage. The management receives in 15, which means the artist receives 85%. That's pretty good. That's actually pretty good, to be honest. That's not horrible. Artists shall, and by the way, here's what happens. If you're not getting, you don't feel like you're getting that worth it, that's not worth it, then you would disengage them. You would cut them out, right? So after a year, fire them, right? But 15% is not horrible. Artists shall direct any third party and to make payments of all gross income directly to manager. Following the receipt of gross income, managers shall deduct the fee and remit the remaining sum to artists within 14 days. In the event that any gross income is received by artists shall pay the manager the fee within 14 days of receipt. So it's a payment requirement. So meaning if anything was received directly by the artist, so anything was like, let's say, PayPal directly to the artist, they've got to pay back that 15% within 2 weeks, which is reasonable, upon receipt, right? So once again, pretty reasonable term. All right, 5. Managers shall be entitled to the fee for all gross income received by artists after the terms for matters of engagements in which the manager is providing services. In the event the artist receives stock, membership interest, or membership units as part of their gross income, managers shall be entitled to its fee upon the liquidation thereof, as taken from the value of liquidation, regardless of if such liquidation occurs during the term or not. So this needs to be paid out when you sell the stock or membership. Right? In the performance of the services, manager may incur related expenses subject to artist prior approval. By the way, if I had a clause like this about stock and I expected the stock to go up, what I would do is this. Ladies and gentlemen, if you receive stock and you expect that stock to go up, I would immediately, upon receival of the stock, sell the stock, liquidate it, and then buy it back. Because you're going to gain more by immediately liquidating those shares and giving them the 15% now and then keeping later. This is obviously hashtag not financial advice. That's just what I would do, because that would fulfill the contractual clause. Because as soon as you liquidate the first time, you sell it to them, then you buy it back, and then it rises. In the performance of the services, manager may incur expenses subject to the artist's prior approval in writing. Such expenses shall be reimbursed to manager from the gross income, in addition to the manager's fee. So this is very fair, but mind you, look, compare this to Niji Sanji, guys. Who's taking the burden here? In this case, the manager is taking the burden, not the artist. Much different than Niji Sanji. So the manager shall provide the artist with all receipts and invoices regarding such expenses, subject to reimbursement. So in fact, this is how Niji should do it. They should be the ones that are incurring the expenses, not the talent, right? Not the talent. So very interesting. Intellectual property. Artist hereby grants to manager all rights necessary for manager to utilize artist name, logo, images, and video, and other non-confidential information. At times, such as manager may need to reasonably designate in furtherance of manager's performance of its services. So manager can use it for them. For any avoidance of doubt and in accordance with such terms, manager shall retain any and all rights into such derivative works only. So manager can create derivative works and they have a license for that. But otherwise, all the IP is to them. So manager can create derivative works. And if it's created by the manager, then it is the property of the manager. Very fair, very normal, very good contractual term there. Booking agent. It is understood and agreed on by the parties that obtaining employment, sponsorships, appearances, commercial engagements for artists by manager is not an obligation to manager under this agreement. A manager is not an employment, theoretical, booking, or talent agent. This is important because in many states, such as California, you have to be registered with the state if you are a talent agent. So let me say that again. If you are a talent agent, a booking agent, an employment agent, or a theatrical agent, you need a license from the state. And since they claim that they're operating worldwide, they're operating in places like California and other countries, which will require you a business license, et cetera, for that. So even though they're doing those things, they're not, because it's kind of weird. If you look at the previous pages, let's go back to like what they're doing in the previous pages. If you look at the services, let's look at this, right? So they're advising the agent on negotiations related to employment and exploitation of the talents and products. That sounds a lot. Advising them related to their employment and their exploitation of talent and products. That sounds a lot like obtaining employment. If you're advising them on that. This is the part where I say, guys, in the long run, I think government will regulate VTubing agencies and will regulate VTubers because they're kind of doing the thing, even though they're saying they're not doing the thing, right? So this is why I think in the long run, eventually people like the regulatory bodies are going to get smart because eventually they're going to look for money and they're going to look for regulation because that's what always happens eventually. Right when you know the boomers are out and people who and by the way, shout out to my boomers out there that understand this, but a lot boomers that are based and understand VTubing, you will understand that many don't understand how VTubing works and don't get it, so they don't know how to regulate it yet. When Gen X, millennials, and certainly Gen Z is in charge and they're working there, they're going to say, "Oh yeah, we know how VTubing works, and we're going to regulate." Because they're going to want money, because they're going to want to pay themselves, right? That's what the government does. Government does that very well. So I think eventually they'll come down on this. But for now, this is because they want to get around licensing regulations. The manager has not offered or attempted to or promised to obtain or seek, procure employment or engagements for the artist. If so directed by the artist, manager shall provide assistance as reasonably necessary with the scope of manager's services to their agent in negotiations with third parties for the purpose of obtaining engagements for the artist, in which event compensation to be paid to the agent shall be paid by the artist in addition to compensation payable by the management hereunder. So essentially saying if they're working as an employment booking agent, like they're working in that capacity, they're going to be owed an additional compensation, even though they're sort of advising on it anyways. All right, now we're back to termination. So we've already got term and we've already seen a termination clause. So they can both already, we've already seen in an earlier section that this is a 1-year contract which renews year to year, and they can deliver notice that it will not renew within 30 days of that yearly date. But in addition, so above and beyond that term, so the term was already in there. They didn't need to put any of the rest of this in here, but it's in here. Either party can terminate upon 30 days written notice. So 30 days notice, they can terminate. Very good termination clause. I like that. for any reason, just 30 days notice. The agreement is terminated immediately upon written notice by a party if there's a material breach of the agreement, if there's a material breach of the agreement which is capable of being remedied but fails to be remedied within 30 days, if somebody is declared bankrupt, charged with a felony, so you're a criminal, or if you commit an act which may be considered immoral, deceptive, scandalous, obscene, which may injure, tarnish, damage, or negatively affect the reputation or goodwill associated with the non-offending party. That's immediate termination grounds. These are very standard, very normal. For the avoidance of doubt, in any event of any termination of this agreement, artists shall have all rights to continue any business relationships with third parties which were previously managed by the manager. So even if this is terminated, the artists can continue with all their other business relationships. Accounting. Upon the request of the artist, no more than once per year during the term, management shall provide the artist with an accounting specifying all gross income received by manager on behalf of the artist in the last 12 months, specifying all deductions and payments, all expenses incurred on behalf of the artist, manager fees, loans, advances, and other funds from gross income received by manager during the accounting period. So you can once a year request an accounting. That's a very important provision. You do need to do that if that is in your contract. Definitely do that. In the event that artist receives any gross income, artist shall be deemed to hold manager's fee in the amount that equals any distributions incurred by manager on behalf of artist in trust, pending payment to manager in accordance with terms herein. They talk about in trust because you're a fiduciary. So if you have a fiduciary duty to guard that trust, to guard that money on behalf of the manager, and if you don't do that, that is a breach, right? Even depending on the state, could be potentially criminal breach because you are creating a trust in behalf of that person. Upon reasonable request of the manager, no more than once per year, artist shall provide manager with an accounting specifying the amount of gross income, if any, received by the artist or by any other party on the artist's behalf in the prior 12 months. So they may have to provide an accounting because if they're holding money in trust. Assignment. Manager may assign this agreement or any rights thereof only to a business which manager is a principal. So they can't just assign it off. They could assign it to another one. Now, this is an important clause. Why is this an important clause? Guys, what does this mean? Manager may assign it. So right now, their business is forfeited. They're looking to start potentially a business in another state. So what potentially could they do? They could assign the contract. The manager may be able to assign the contract. Artists may not assign this agreement without manager's consent except to a loan out company of which the artist is a principal. So manager may be able to create an LLC. Let's say they create a Delaware LLC instead of Maryland. Delaware is the gigachad of company states, right? Very good. Wyoming's also good. So is Nevada, but Delaware's pretty good. So they could create a Delaware company and assign it to a Delaware company. MSM could do that. Representation and warranties. Artists represents and warrants they are no longer under disability or prohibition from executing this agreement and performance thereof. This is interesting. So pay attention to the manager's representations. Artist further warrants and represents that no act and omission by the artist hereby will violate any right or liability of any person or any third party intellectual property rights. So you're not going to violate anybody's IP. You're going to play nice. Artist shall not violate the laws, and if applicable, agrees to obtain the licenses, permits, and consent. So the artist is saying the artist is going to get all necessary license, permits, and consents by any state, federal, or other governmental agency. Artist agrees to exert their best reasonable efforts to develop their career and cooperate with manager to the fullest extent in accordance with the terms herein to develop artist's career. Artist represents and warrants there are no agreements to which it is party that might conflict with or interfere, limit being consistent with, or affect any provision of this agreement. All right, here we go. Manager represents and warranties. It has authority to enter into this agreement. We're going to come back to this in a second. and to be a provider of the services listed in Section 4 for the artist. Manager further represents it as the experience, capability, underline the word capability, and resources to perform the services in a professional, timely, and competent manner. Okay, this clause B is where we have a problem. Houston, we have a legal problem. This is the first place where we're gonna come up with a big problem for these guys because they are actually not able to do this. Why? Why? Because they cannot enforce anything against other people. So they cannot bring actions in court. So how can they protect their talent if they cannot bring actions in court? They're not a real entity. So because they are not an entity that can actually protect their talents, they have no ability, no capability to do this. So they are in breach of contract. So what happens is, so for example, right now, and let's bring up the point here, right? So our boy Cabal brought up, and I'm brought up where he is right about this, right? So Cabal, who's one of their talents, right? The rampant misinformations, half stories, influenciation of myself and colleagues have been grossly insulting. Transparency is at the basis of our business relationship, which may be true with your relationship, but the problem is with the contract, right? So, he was posting, oh, the law is renewed, and oh, look, our laws are valid, our contracts are valid here, right? Yes, you, Cabal, can sue MSM, but they can't sue you. And right now, they're breaching your contract, homie. Right now, homie, they are in breach of contract. If you sued them, you would 100% win. Any member of talent right now, if you are a member, and I'll say this, Clippers, clip this. If you are a member of MSM Talent and you were unsatisfied with your contract, it appears based on this contract, if your contract is similar to the contract I'm looking at, which is this contract right over here, right? If this is a clause that you see in your contract, when you look at your contract, if you're seeing this provision that the manager is representing and warranting that they have the authority to enter into this and the capability and resources to perform the services, that is in breach. They have no ability to do that. They are not a real entity. If you wanted to sue them, you could. You don't have to. You could just say you're happy. You're happy doing business with a corporation which can do nothing for you because they can't bring a claim. They can advise you. They can do stuff, but they can't protect you in court. So maybe I misspoke there saying they do nothing for you. They can do things for you, but they're limited in what they can do for you. So can they pay you money that YouTube pays them? Sure. They can pay you money that YouTube pays them or Twitch pays them. Sure, they can do that. But let's say that someone was defaming you. Can they defend you in court? No, they cannot. So is that something you want? That's a question for you. That's a question for you as a talent. Is that something you want? And if you wanted to leave your contract, you could do that without 30 days notice because, well, it is what it is. And they can't bring a claim against you if they're not an actual entity, right? Now, that'd be bad from a business standpoint, right? But could you? Well, seems like it if this is your contract. So let's continue. There's more. We're not done yet, guys. We're only on page 7. We got at least 4 more pages. Confidentiality. All right. Confidentiality. The parties now own and will develop compiled proprietary techniques, trade secrets, confidential information, which have great value. This is called the confidential information. Parties may disclose confidential information to each other during the performance of the services. Confidential information does not include only information disclosed by the parties, but also information developed or learned by the parties about the other businesses and its practices. It includes all information which has commercial value or utility. This is so broad. I know it's in every agreement, but it's always so broad. Everything has commercial value and utility. But anyways, of the unauthorized disclosure of, which could be detrimental to the interest of the disclosing party, whether or not such information is or has been identified as confidential information. Confidential information also includes any and all information concerning discoveries, developments, designs, improvements, inventions, formulas, software programs, procedures, techniques, know-how, data, research techniques, marketing, sales, whether financial or business information, scripts, derivatives, improvements, enhancements, to any of the above. Confidential information shall also include third-party information, which is in either party's possession under an obligation of confidential treatment. The parties shall at all times keep it confidential and not divulge, communicate, or use the confidential information of the other party without express written consent. So this is a mutual agreement. So both parties keep each other's secrets. Normal. The parties further agree not to cause the transmission and removal and transport of tangible embodiments of or electronic files containing confidential information without prior written approval of the originating party. The parties' obligations with respect to any portion of the confidential information shall not apply when the information is in the public domain, has entered the public domain, or was in receiving the party's possession fee of the obligation of confidence at the time it was communicated to the receiving party. It was also rightfully communicated to the receiving party free of any obligations subsequent to the time it was communicated between the parties. I'm just going to say here, one of the biggest risks about this contract not being valid, one of the biggest problems here, guys, and this is a huge problem for them, is that they have no ability to bring a claim in court to stop people from leaking their confidential information. So if somebody associated with, somebody leaks confidential information, this company, MSM, cannot bring an action in court to stop them from leaking that information. That information can just get out there because MSM can't bring the claim. So people can leak and they can't do shit, is what I'm saying. Right now, any leak is fine. In fact, to the extent that they may include this contract, maybe they'll say, oh, this contract was confidential. No, it's not. It's not confidential because you can't enforce that. So anything that shows up can't be enforced because they can't enforce it. MSM can enforce it. You can enforce it. You can enforce it. Because they've made a covenant to you. So you, as the creator who signed this, you can enforce it against MSM, but they can't enforce it against you. 9, indemnification. Here we go. Manager shall defend, indemnify, and hold harmless claims and cause of actions, liabilities suffered by either party arising in connection with any negligent act or omission, intentional misconduct, or breach of this agreement by manager. What this means is this: any fuck up that arises from this, you can sue them, you can hold them harmless, but guess what? They cannot bring any action to hold you harmless or to have that power of your indemnification. So right now, the manager is indemnifying the artist, but the artist is not effectively indemnifying the manager because they don't have a valid entity. Do you understand how much this puts on the company? The company is put in like an immense amount of liability on themselves here, right? An immense amount of liability on this. Governing law, state of Maryland. The parties shall endeavor to resolve all matters amicably without need for a party. Should manager or artist be unable to resolve a dispute, the dispute shall be resolved by arbitration under the rules of the AAA, the Arbitration Association, by a single arbiter. They cannot force this. Because they are not a party, they cannot force this to arbitration. So this clause is null. No, unless the artist wants to voluntarily go to arbitration, they decide I want arbitration. And they decide to go, they could just tell them to fuck off because they're not an actual entity. So they can't be forced into this. This arbitration one is done. Now, it's smart to have an arbitration clause. This is smart, right? It's less than a lawsuit. So this is actually clever. I like arbitration clauses like this. But it's unenforceable right now, unless the artist wants to do it and the manager wants to do it. They both agree to it. But otherwise, artists can say fuck off. Miscellaneous. Artists acknowledges that they have the opportunity to consult with counsel. Paragraph headings are for guidance only and shall not have any effect. That's normal. As the context requires, terms of the masculine include the feminine and neuter, and terms in the singular include the plural. This is very normal for contracts. The agreement contains the entire understanding of the parties as to the subject matter thereof, and all prior agreements as to the subject matter have been merged herein. This agreement may not be altered anyway except by instruments signed by the parties. This is standard boilerplate language saying, hey, this is the whole agreement. There's no other secret agreements. This is it. The agreement may be signed in counterpart, facsimile, PDF, each of which is deemed to be an original, but all of which together shall constitute the agreement. This is true and normal, very, very standard boilerplate stuff. In the provision that an agreement, if any provision of this agreement is invalid, void, or unenforceable, the remainder of the agreement shall be in full force. So, for example, many sections here are now void because the manager is no longer a valid entity. So, because of this, Kimbo is right that there's certain parts of this contract that are invalid. But also, is Cabal right that the entire contract is not invalid? Yes. There are parts of this contract that are valid and enforceable. That is very true. That part Cabal is correct about. It's enforceable against MSM. Against MSM. Right? The manager here's the contact information. And what do we see here under the contact information? Seth at msm.fm, Seth at msm.gg. So we got Seth on the line here. Expiry or terminations agreements shall not release the parties from any liability right to action, which upon expiry or termination has accrued or may accrue. Expiry or termination shall not affect the coming into force or continuance of any provision hereof, which is expressly or by implication intended to come into force on or after such termination. And then you go ahead and you see the signature of Seth Weinstein, owner and talent manager of Mad Scientist Media, LLC. Client reads and agrees this in its entirety, and they acknowledge if they have any rights or questions on this agreement, they had the opportunity to review it by their attorney prior to execution. So there we go. That is the contract from Mad Scientist Media. Now, what's my rating? This is actually a pretty good contract. If the entity was legal, if the entity was valid, this would actually be a good contract. This is not Niji Sanji, people. So I'm just saying, like, this is actually a decent American style contract, which I think is not that problematic. So in terms of like contract terms, especially when you compare it to stuff like Niji Sanji.